Welcome to IEF's Conservation Chat. This is our first chat of the year. We're really excited that you've joined us today from all corners of the globe. As you're logging in and we're waiting for other people to log in, if you'd like to put your name and maybe your affiliation or where you're from in the chat, we'd love to see who's all on the call. I know it looks like I see a lot of familiar names out there. So if you'd like to just pop that in the chat, that'd be great. For those of you who don't know me, my name is Julie Bates, and I'm the Donor Relations Manager for IEF. And we have some other staff members on the line with us today, too. We have our Executive Director, Deborah Olson. We also have Sarah Conley, who's the Director of Conservation, and Dr. Chase Ledoux, who is our Special Project Manager. Before we dive into the chat, I want to go over a few little housekeeping notes to make sure that we have a great session for everyone. Please remember to keep your microphones on mute just to help minimize background noise. Also, we'd like for you to keep your cameras off because it also helps maintain bandwidth since we have people coming in from all over the world today. Also, just so you know, we are recording this session. So this chat will be recorded and it will be available later on on our YouTube channel. If you have questions for our presenter, we ask that you put those in the chat and we will come back to those as we can. Yeah, and so I guess that probably wraps up most of the housekeeping. So I'll turn it over to Sarah Conley now, who's going to be our moderator today.
Hi, everyone. Thank you, Julie. Welcome to our first conservation chat of the year. We are so excited to have a longtime friend of IEF, an advisor to IEF, an expert that we rely on quite a bit. We are joined today by Laura Vandermeer. She has over 3 decades of experience in international elephant law and policy. She works with companies, associations, nonprofits on government relations, advocacy, coalition building, and regulatory compliance. Her current work largely focuses on policy processes under multilateral agreements and the implementation of international rules in domestic legislation. I know that sounds complicated, and it is, but that's why we have a specialist here. And so, Laura, welcome. Thank you for being here to share your knowledge with us.
Thank you so much, Sarah. Go ahead and share my screen.
Yes, please.
All right. And Sarah, are we all good? You can see it?
We can see it. Go ahead, take it away, and then we'll open to questions once you're done.
Okay, perfect. So hello, everyone from Corners of the Earth. This is very exciting. Thanks for joining us today. CITES can be quite a complex topic. I'm going to try to keep this to the straightest lines possible to explain it. I know that we have folks on the phone who probably know a lot about this, maybe more than I do, and you can share your experience. And we also have people who might be a little bit new to CITES. So we will start with kind of a CITES 101 primer, and then I'll go into the main topic of today, which is about mechanisms under CITES to facilitate scientific research for species conservation. So, and I'm not advancing. There we are. So CITES is the International Convention on International Trade in Endangered Species of Wild Fauna and Flora. It was created in Washington, D.C., which is why sometimes and in some countries it's referred to as the Washington Convention. Today it has almost universal coverage and scope, so 184 countries are party to CITES. And CITES operates by the text of the convention itself, which is legally binding on all the parties, but also on decisions that are made by what is called the Conference of the Parties, and we refer to that as the COP. And that COP gets together every 3 years and makes a whole variety of decisions that implement the convention and also decide what should be covered, which species should be covered and subject to the requirements of the convention. Another thing that is done under CITES is to develop resolutions, and those resolutions help to interpret and apply and implement the convention but they're not legally binding on parties. So you will see that different countries implement all of the legal requirements as they must, but sometimes handle the resolutions and the special procedures a little bit differently. And we'll come back to that in a bit. So there are three appendices under CITES, but the two that are really the most important for our purposes especially are Appendix 1 and 2. So Appendix 1 are essentially endangered species, and commercial trade is prohibited. For example, most populations of elephants are considered endangered species, and commercial trade would be absolutely prohibited. Then we have Appendix 2 species. These are not endangered, but they are species that might be threatened with extinction if we didn't control the trade in these species. So that's a lesser level of protection and no prohibition on commercial activity, or at least not a universal prohibition on commercial activity. So something that a lot of people don't know is that CITES applies not only to live animals and plants. I never talk about plants, by the way, I'm not really a plant person. So it applies not only to live animals, but also all of the readily recognizable, as the language goes, parts and derivatives. So everything from that live elephant that you see in the picture there to hairs from that live elephant would be covered by CITES. And they would require, if you're going to move the hairs or the elephant from one country to another, you would need government issued permits to enable that international trade. There are three main requirements that you have to meet in order to trade internationally, CITES listed species. So in all cases, it has to be the case that the specimen you have, and a specimen again can be a hair or an animal, is legally acquired, and you have to be able to show that the trade in that animal or that specimen is not detrimental to the survival of the species in the wild. And then only for Appendix 1 species that the trade is not for primarily commercial purposes, obviously because commercial use is prohibited. So there are certain things that are excluded from CITES, and I'll start with the woolly mammoth. That is excluded from CITES because CITES does not cover extinct animals, species, or plants. So that you can put aside. And then there are basically three different categories of things if we think about exclusions or exemptions. The first is if something is not considered to be readily recognizable, then it is excluded. So for example, urine and feces, these are waste products. They're not considered to be a CITES regulated part or product. There can be a difference between what CITES considers readily recognizable and what an individual country might. So that's why I've got an example here. You can see that there's a difference between the CITES list and the US list. The US, for example, does not, in its regulations currently, include coral sands and coral parts as excluded. The second large category of exclusions or exemptions is called the scientific exchange mechanism. And this is for biological samples that are being exchanged between registered entities in different countries. And the word museum is actually used in the convention. So you can imagine back when this convention was made in 1973, this largely referred to museums. I think that today we all have kind of a broader perspective about the word museum, also perhaps including, for example, biobanking and that type of thing. But in any event, if entities are registered in both of the countries and they are exchanging and trading small samples of biological materials between the two registered entities for non-commercial purposes, then no CITES permits are required at all. In the United States, and again, I'm going to keep giving US examples, but I know that these things can be slightly different and are called different things in other countries. So you would have to look at your own regulations in your country to see how exactly these things are implemented on a country by country basis. But in the US, this is called a COSI, a Certificate of Scientific Exchange. And that is what you need to get as part of your registration to be enabled to trade these samples without CITES permits. The third category is bred in captivity specimens, or specimens that have been bred in captivity, born and bred in captivity. And this is a very specific definition under CITES. It doesn't literally mean just born in human care. there are certain requirements that have to be met in order to be a CITES compliant bred in captivity specimen. When that is the case, and you have a bred in captivity certificate for that animal, for example, which is marked with a C code, which means that it's bred in captivity, then you need an export permit, but no import permit. And in this particular case, either commercial or non-commercial uses could be allowed. So, simplified procedures. Here's my main point here. Simplified procedures are a way to enable people to move samples, in particular, more readily than going through the very cumbersome application process on a one-off basis. So, normally, if you were going to move an elephant from one country to the other, or a sample, you would apply for an export permit. If it's Appendix 1, you'd apply for your import permit. You have to wait for both governments. They have to communicate, and then the shipment could go. That can take a lot of time, particularly in the United States. It tends to take a lot of time to get those permits. So CITES actually recommends, this is again a recommendation, it's not legally binding, that parties use simplified procedures to issue permits and certificates to facilitate and expedite trade that has no or little conservation impact on the species concerned. And specifically, this can be done for biological samples, also for those captive bred animals, and in other cases where the management authority thinks it's appropriate. So these simplified procedures, if we just refer to biological samples, there's actually an annex that lists the types of samples, the types and the sizes of the typical sample that would be qualified for these simplified procedures, and the reason why these samples are urgently required to move and should be expedited. And one of those reasons is for species conservation. So this is a picture of just part of that Annex 4. And here you see, for example, blood and derivative components is the type of sample, 5 milliliter maximum for liquid, etc. So you see typical sizes and types, and then on the final column, you see the uses of the sample. You'll see biomedical research, you'll see all sorts of things in here, disease testing and so on. So this annex provides the list of the types and sizes of samples that can be moved under this simplified procedure. And I want to draw attention to the fact that this annex, and you see the large arrow there, actually excludes materials for reproductive purposes. So all reproductive materials are excluded under the CITES resolution. So what are the benefits? Well, if we could simplify permitting, it would save everybody a lot of time and resources. So both governments, as well as scientists, researchers, conservationists, etc. And more time could be spent by government authorities focusing on high-risk trade that's proposed, the important permitting work, illegal activity, that type of thing. And scientists and researchers could spend more time doing their research and controlling disease and so on, rather than spending time filling out permit forms. The other reason why simplified procedures are important in this context is because there are many biological samples that are time sensitive, and you don't have the luxury of waiting for a long and drawn out permitting process. So the simplified procedure should enable time sensitive biological samples to arrive wherever they need to arrive before they're destroyed or compromised. So how does it work? So the CITES resolution recommends that the authorities at the national level develop generic, non-detriment advice. So the authority looks at the research that's going on, the entity who's doing it, where the samples would be coming from, and they agree after that consideration that this is not detrimental to the survival of the species. And in fact, in our case, it's actually not only not detrimental, but it's positive because it's enabling conservation research. And they take into account in issuing that non-detriment advice how actually the samples are being collected, because that's an important component of considering non-detriment. And once that determination is made, then the government, the party, provides the people or the entities with partially completed permits. And these partially completed permits remain valid for 6 months if it's an export permit or up to 12 months for an import permit. And I'll show you an example in just a couple of minutes. The authority then also, of course, maintains records of all the people they issue these partially completed permits to and the species that are being traded. And the parties themselves, or the permittee themselves, maintains records and reports to the government on all of the ways that they've used their permit. And again, I'll come back to a specific example so you can see what that looks like in the US. The other recommendation that is made by CITES is that parties should expedite processing the applications for biological samples of the types and sizes specified in that Annex 4. So here's an example. You can see a little snippet here of an actual import permit. And this particular one, if you look at the red arrows, you'll see it applies to a certain species, i.e. African elephant here, and very specific types of samples. There's not a size limitation here per sample, but there is a specification of what types of samples are allowed. So that is one way it can be done. But if I draw your attention to the green arrow on the other side, we should note that there are entities that have authorization and partially completed permits to collect any types of samples from any endangered species. So the government who issues this partially completed document decides on how specific or broad it is, depending on the entity that's involved and the type of conservation work that's going on. Here's another little snippet of that same permit. This is actually the top part of the permit. And you see here how it works. I've blocked out the permittee here in the big black box there. But what you see is that box 4, where it says consigner, the name and address in the country, this is where the sample is coming from. That is left blank. And if you see in box 5, where the big arrow is, there are special conditions. And those special conditions authorize the permittee, the one who has this permit, to actually fill in box 4 and say where the sample is coming from at the time they know where the sample is coming from. And that's the beauty of the system. They also are authorized to fill out other boxes like how many vials of blood or how many elephant hairs or what have you. So that's how this works. And this is why it's called a partially completed permit, because the authority has completed components of it and has authorized the applicant or the permittee to fill out the other parts when each shipment is made. And you see here in block 5, just above that arrow, it says that the permit can actually be copied for multiple shipments. So you would make a photocopy of this, you would fill it in for the first shipment, you'd make a photocopy, you'd fill it in for the second shipment number 2. So that way you'd be able to import samples from different countries and different places of different size, etc., over the course of the period of validity of your authorization. In the United States, we have something called a Form 3177 declaration. So when you actually would use your permit, then you would file this declaration so that the US government is alerted to the fact that you are you're importing this sample on that particular day. So this is what alerts the US to know that that partially completed permit has been used. And of course, as I mentioned earlier, the permittee has to produce a detailed annual report about how they use their permit, all the specifications and details. So that's the record keeping component of this. So in the US does implement this simplified procedure. And in our regulations, which are referred to as the Part 23 regulations, you see a particular provision that explains to the public exactly what the requirements are for issuing a partially completed CITES document. And you will see if you look at Part 23.51 that in the US, all biological samples are covered. Excuse me. There's no reference in the US regulations to that CITES Annex 4 that provides the list of samples and sizes. So the US system is effectively less restrictive than the CITES resolution, which is perfectly fine because the resolution is not legally binding, and it allows all different types and sizes of biological samples, just more general. That means that for the US, this system can be used for reproductive materials, and it is being used for reproductive materials for some permittees. One of the challenges that people have with the system is A, they don't know about it, which is partly why I'm talking to you today, and B, there's not necessarily a specific application form. So when you are applying to try to get these partially completed permits, it can be a little complex to figure out which form to use and how to fill it out because the format that you use is actually the general format used for single-use permits, which doesn't really lend itself to all of the questions and the type of information that you need to be able to provide in this case. For example, normally, if you just were looking for a single permit, you would be able to say exactly what you want to import from where, the address, the size, the type, etc. But in the partially complete situation, you don't know that yet. That's the whole point. You don't know yet, so therefore you can't fill out all that specific information called for in the application. So the application format can confuse some people and be a little off-putting sometimes. Also, there's not, to my knowledge, there's not a standard system for expediting this type of application versus other type of CITES applications, at least in the United States. In other countries, maybe there is. The other thing that we have in the US, and I think this is a little bit unique, we have something called the master file. I'm not entirely sure sometimes what that word means. People use it in different ways. And so I looked just to the US Fish and Wildlife website, and there you see the quote that I have here. This is the language exactly from the website of the Fish and Wildlife Service. So master files may be obtained for overarching programs that require multiple exports. And you see that once your program is approved, a master file may be valid for at least 1 year, not to exceed 3. And then you apply for individual partially complete permits that you customize for shipments. I believe it's the case that this should be available for Appendix 1 and 2 species and for import and export. But I'm not sure that that is actually the case in all situations for all applicants. That's a little bit less clear to me right now. But anyway, we do have these mechanisms, and these mechanisms are really meant, again, to help both the permittee, the applicant, to get on with their research, and the government to reduce repeated permitting processing when it's not necessary because these small samples do not negatively impact species conservation in the wild. So this is my question to myself. Okay, we've got actually a pretty good system here. We've got CITES simplified procedures. We have a couple of different options. We've got different ways of doing it. We've got these partially complete permits. But how could we improve it? Well, on the US side, looking at the Endangered Species Act, which is what we use in the United States to implement CITES, and the regulations that go along with ESA, could we, for example, codify some things? Could we clarify some things to help applicants better understand what options are available to them and what the timeframes are? And would that not create greater transparency for everybody? Perhaps enable more people to use these special procedures that not everyone's aware of and kind of create a more level playing field, not only for applicants within the United States, but for US applicants vis-a-vis applicants in other countries. I think that we should be doing everything in our power to ensure that permitting doesn't get in the way of conservation. In fact, permitting should help and enable good scientific research and conservation. So one suggestion there might be maybe a combination approach. And again, this is US specific terminology, but maybe there should be a standard period of years that everyone who applies for the first time can get if you have a multi-year research project, which many people do. Maybe it should be 3 years, I don't know. A combination of that master file, which gives you an authorization for a period of time, paired with perhaps an automatic, and I'll asterisk that word, issuance of these partially completed import permits or export permits within the 3-year, let's say, period of time that this authorization is valid for. So the idea being that you could actually, as long as you are submitting your reports on time and your reports are appropriate and complete, and they demonstrate that you're fully in compliance with permit conditions, why not just go ahead and issue that next export permit or import permit for the next period of time within that broader authorization period. Why not do that to further simplify and expedite and enable scientific research? You could also think about in regulations, you could think about actually putting in place a time-bound target for how quickly these types of applications should be processed. You could consider, again, very specific to the US context, excluding this particular type of application from the public notice and comment requirement, which of course adds time to the permitting process. That's with respect to the US. But a bigger question I have is what about at CITES? Beyond what we have today for simplified procedures, would it be possible to actually have an exemption to exclude from permitting requirements? I'm just going to call it de minimis quantities of biological materials for scientific research. This is for non-commercial research based on the fact that these itty bitty tiny pieces of tissue or hair or bone or what have you are not readily recognizable and not only, again, are not detrimental to species conservation, but they actually are bringing benefits to species conservation. That's a question that I have. And one of the reasons I have that question is because just last year, an NGO organization that participates in CITES put a paper out on the table for everyone's perusal, actually proposing this. And when we looked into some of the details of this idea, we found that the idea of exempting de minimis quantities of biological materials from all permitting requirements, again, for scientific research for non-commercial purposes, had been proposed by the government of Denmark many, many years ago. And it never really got off the ground. But the question is it time to start thinking about that again and asking the question, what else can we do to enable and facilitate and encourage species conservation through scientific research? So that concludes my remarks, and I think we're going to do some Q&A. I hope that was clear. Happy to answer any questions you might have.
That was great. Thank you, Laura. So why don't we start off with our first question? How did you get involved in this line of work? I know you are a lawyer, you're legally trained, but how did that segue into CITES and doing this kind of thing?
Well, I was a young associate at an international law firm, and I wanted to practice environmental law. And so I kept my ears open for any work that might take me in that direction, and particularly international environmental law. And a senior lawyer in the firm one day happened by my desk and had a project. There were some imports proposed actually from the Russian Federation to the United States, and the U.S. Fish and Wildlife had denied those permits. And so that led to a series of inquiries about that particular matter. And I was sent off to a CITES meeting, and that was in 1994. And I can tell you I had no idea what was going on or what to do about it. So I've been able to experience those meetings many, many times since then. And I've really focused on this area as part of my work. And I get many questions from young lawyers today about how they can get involved in this field, which is now a growing field. It wasn't when I started in it, but now it is.
Excellent. Yeah, well, you find your niche and you just go there. So some questions about specific things. Do the regulations differentiate reproduction by artificial insemination versus natural reproduction? I know there are some regulations that are changing in different countries that don't necessarily allow reproduction of elephants in ex situ circumstances, but how about as far as CITES is concerned?
So CITES doesn't address that because CITES is only about the trade in and of itself. However, as you've seen from the slides, if you are to move gametes for artificial insemination, that is exactly the same as if you move an animal. So the same permitting is required to move those eggs or whatever as if you were going to move the animal. If you think about it from a welfare perspective, then it would make sense that you would exchange gametes and materials rather than moving animals around in order to create greater genetic diversity. But that is not how you do it is not regulated by CITES. It doesn't speak to that. It's really just a trade convention.
Okay, excellent. And about CITES in general, maybe talk to us about how decisions are made in CITES. What is the process if we're going to make changes? So if this de minimis idea was to go forward.
So decisions are made by the countries that are party to the conventions, those 184 countries, generally by consensus. That's the preferred way, and that's the typical way of decisions being made. However, if a decision is contentious or there's a close call on it, a party may call for a vote. And then, depending on the rules of procedure and the particular thing they're voting on, whether it's a simple majority or two-thirds or whatever, that all depends. So there could be a vote to make a decision. And when we are at these conference of the party meetings every 3 years, basically a conference of the party is the end point for work that's been going on for 3 years, and it's the starting point for the work that will go on for the next 3 years. So at the conference of the parties in November of 2025, a whole bunch of decisions were made, and those decisions basically set out the work that needs to be completed by the technical committees, the animal committee, the plant committee, the standing committee, which deals with more political issues and broader issues. So what happens is if there is work to be done on facilitating rapid movement of biological samples, for example, there is work on that, then it will go to the animal committee or to the standing committee. And there will be deliberation. There usually will be a working group that is created with governments, a chairman or co-chair, and then also NGOs and stakeholders and international organizations. And that working group will work in between meetings to try to advance the topics, bring them back to the next year to the meeting of the technical body, like the animal committee meeting. And it would get decided, and the animal committee would then make a recommendation out to the conference of the parties for decision. So that's how things get done. And this de minimis quantities idea, that could come up as part of the ongoing work that already is happening, has been happening for a number of years about the rapid movement of samples and how to facilitate it as a proposal from someone in the working group. Or it could come just because a government, as I said, like Denmark had done many years ago, before the next conference of the parties, they could put together a decision document actually calling for a decision to be made on a particular thing like this. So it can bubble up through the work, or it can actually be prompted by a country calling for a particular issue to be resolved in a particular way.
Interesting. Okay. So say something happens change-wise in CITES, how is that change made in U.S. Fish and Wildlife Services, for example?
So, well, just speaking more broadly, not to Fish and Wildlife in general, specifically. So after the conference of the parties, you will have decisions that have been made about like species that have been added to the appendices, taken off the appendices, moved up, moved down. You'll have all these other decisions I've been talking about. And for all the things that are legally binding and for all the things that countries wish to implement because that's what they've included in their system, they will then make the necessary changes to incorporate the decisions that come out of that conference of the parties. And so you'll see a revised law coming out, revised regulations in the European Union that automatically apply to all the EU member states. You'll see all the countries updating their national implementation of CITES because that is what they're bound to do. So when there are legally binding things, they have to do it, and they'll actually change their laws or their regulations to reflect those legally binding decisions. And again, sometimes also to reflect changes made in things that are not legally binding, but the country chooses to implement them in a binding fashion.
Excellent. Okay. And question in the chat, is CITES involved in monitoring violations or illegal activity associated with these biological samples?
Well, CITES would be involved in, can be involved in any situation where there's illegal activity, where there's a alleged violation of the convention. And there's a whole body of work that goes on dealing with illegal trade, not of biological samples in particular. In fact, I'm not aware of CITES working on that particular issue at the moment. But there's a lot of work that does go on that looks at trade, looks at anomalies, has various systems that try to trigger alerts, if you can call it that, for things that might not comply with CITES, that then the CITES parties can take a look at, they can examine, they can go into great detail, or they can decide it's not an issue. And you can actually then move into compliance procedures. This has to do with governments primarily because it's governments that have the legal obligation. But of course, it can involve trade that occurs with anyone, with any stakeholder, any institution, any person around the world, where a government has given a permit or not given a permit. So yeah, absolutely.
Okay. And if there is a violation found, something like that, what kind of consequences can we see?
So typically these multilateral agreements meaning agreements, legal agreements between countries. So typically, CITES and other multilateral agreements have compliance mechanisms and procedures that try to facilitate compliance. That's the first thing you want is to bring people into compliance, not to punish them. You want everyone to try to comply. So there will be assistance provided, technical assistance, capacity building. There can be deadlines set, for example, for a government to implement certain requirements in order to come into line or to rectify a situation. There's a lot of back and forth between the Secretariat and its legal officers and its enforcement team and countries that are part of these compliance procedures. And it can result in anything from a decision that everything's okay, all the alleged issues or whatever have been resolved, to actually a recommendation or a formal suspension of trade for a species, for a country, for more than one country. So there actually are concrete consequences for failure to comply with the legal obligations of CITES for parties.
Okay, good. Um, Another question I got sent to me. So, how about in the US specifically with US Fish and Wildlife Service, if uh, changes need to be made to their policies, not necessarily directly related to CITES, does that go through Congress? What's the procedure to get those changes through?
So laws are made by the Congress and they are implemented by the agencies. So if there are, for example, the Fish and Wildlife Service, the Department of Interior, it can propose amendments. It can change its own regulations because those are implementing regulations. If you wanted to change the ESA, you would need the Congress to act. So that's basically the divide.
Okay. Difference between letter of the law and the implementing procedures.
Difference between laws, what in some countries refer to as statutes, and implementing regulations that are at a lower level and are subject to a less difficult process to change them.
That's an important distinction. Thank you. Um, Another question about the de minimis samples idea. So someone is asking, how would the potentially excluded aspects that are de minimis for scientific research not be considered commercial? And how would potentially abuse or criminal activity regarding those samples from any permitting requirements be addressed, if not by some sort of form of government oversight?
So there are different ways you can have controls. One way you can have control is that even if there aren't permit requirements, there could be labeling requirements or an accompanying document, for example, that has to be with a sample to differentiate potentially. We're just talking here about an idea, so we don't
Oh,
know
yeah.
what the contours of this would look like. But there could be, for example, that requirement that you must have this particular document that provides a certain amount of information and contact information that goes with these excluded de minimis samples. That's one thing. Second, you can have reporting requirements. Another option is you could do something like what we have for the COSI today, where entities that avail themselves of this have to be registered with governments and have to actually be on the CITES website as registered entities, and only they would be qualified. And that kind of gets to the first part of the question too about commercial, non-commercial. You could make a decision that only registered entities who clearly are using these samples for non-commercial research would be allowed to register. So there's all different ways you can get at those different questions.
Excellent. Yeah. Seems like there's options to make this more efficient for both sides. Um, Question from a range country. In your view, do you think that we as CITES can help in ending the ivory trade or poaching in general?
Wow, that's a question that's way beyond biological samples. I think CITES is a really important international agreement, multilateral agreement that can get results. I'm just going to leave it at that. CITES has a role to play.
Absolutely.
Absolutely.
Yeah. Well, I don't think there's a silver bullet that solves every problem, but there's definitely a toolbox, and CITES can be part of that toolbox.
Right.
Uh, Another question. Can you possibly give a couple of examples of transfers within the US or imports of live or biological materials, biological samples, and sort of talk about maybe the different nuances around that?
Um, Not sure that I've got the entire question, so maybe if the person wants to come back with a specific thing, but I will react to a couple of things. One, so this trade would not be within the United States at all because we're only talking about trade into and out of countries. So only if it's international trade. Examples of samples, I think that that list I showed earlier that showed, vials of blood, fresh tissue, frozen tissue, those are all the types of things that are being moved by academic institutions in many, many countries, by museums, by zoological facilities, all doing conservation research. But if there's a more specific question, I'd be happy for the person to add to the chat.
Yeah, we'll see. Um, let's step back a little bit. For maybe the lay people in the audience, can you describe how CITES maybe affects them in their daily life or in their lives? Because I think this is I mean, the samples specifically are very specific to researchers and people doing on the ground conservation work, but I think CITES in general does touch our lives in different ways that people maybe don't know about.
Well, I would say, for one, for people who aren't familiar with CITES, it might be comforting to know that this instrument exists. And it's a very serious agreement and process that does everything it can, not perfect, but everything it can to help ensure that trade does not jeopardize the survival of species in the wild. So CITES is helping to protect endangered and threatened species each and every day. And you may not know about it. You may not know about the individual permit requirements or anything else, but you can rest assured that for countries all around the world and the people who live in those countries, CITES is an important part of helping to preserve and conserve those species for the benefit of indigenous peoples and local communities, et cetera, et cetera. And I would also add that even though CITES is only legally binding for the parties that are the countries that are parties to it, the 184, 86, forgot now. Even though that's the case, other countries that are not party that want to trade in CITES listed species with countries that are party, they still have to issue permits of some kind. So if you're outside of CITES, you still would have obligations, and CITES would still have a positive effect if you're trading with any of those countries who are party, because then the rules of CITES would apply to that trade.
That makes perfect sense. And just to sort of flag for people, CITES, because it deals with the animals and plants, it could be CITES issues could be relevant to the wood in your musical instrument, or to different food that you might have, like caviar. I mean, there's many things besides sort of blood samples from elephants that CITES has fingers in. So it's one of these global things that is working in the background.
Yeah, and I think with that, that's a good point. I would then follow up in my answer to say there are also special procedures and permitting facilitations for things like you've just mentioned, for musical instruments that travel around the world in orchestras and so on. There may be a little tiny piece of ivory in an antique bow, or that bow may be made of a particular type of wood that is controlled and regulated by CITES. You might have something that you inherited, a piano that has some ivory on the keys. All these types of things can be moved around the world, and there are procedures for that. And sometimes it's called a personal effect. So you actually would have a piece of paper that would allow you to move this thing with you because you're not buying and selling it. You're simply moving it with you when you move to a foreign country. Or, as I said, to facilitate the movement of traveling exhibitions, for example, that may have controlled species or musical instruments. So there's all sorts of different provisions in CITES. We've just touched on the tip of the iceberg here with these biological samples.
Very good. Thank you. Okay, so we do have a follow-up in the chat from that question earlier. Um, what steps or permits would an entity need to accomplish for biomaterials import or export? I think you covered that a little bit, but maybe talk about more of the details on that.
So if it's an Appendix 1 species, you would need both an export permit from the government of the country where the sample is coming from and an import permit from the government of the country where it's going to. So you would have to apply to both of them, and you'd have to follow the national process for filling out the applications, what have you, whatever's required in that country on both sides of the equation, both sides of the transaction. And so what it would look like in practice depends on what formats and so on people offer. I mean, one thing I would mention, a great development under CITES that's been just growing like a snowball, if I can put it that way, is electronic permitting. So a lot of governments have really very good systems where you can apply online through an e-portal. So we're not mailing pieces of paper back and forth and so on. And those systems tend to be very efficient, and they can typically call upon existing information in the database of that country to facilitate and expedite the findings that need to be made, because governments make these same findings over and over again. For example, in the biomedical research industry, the same types of samples are moved, tens of thousands of samples are moved. So sometimes existing advice can be called upon to help expedite the next request that comes in. And those electronic systems are really good at that. So in countries like France, Switzerland, Germany, those systems are like clockwork, and they result in really, really quick turnarounds. So you may or may not be lucky to be in a country that has a system like that, but there's also capacity building for countries to help more and more countries get online with those types of e-permitting situations. And there's also work going on about recognition of CITES permits, digital recognition, using the technologies we have today, just like it is for people. When you go to the airport today, depending on the particular airport, the country you're in, the experience can either be very traditional or very tech-based and expedited in terms of, looking at certain technologies that recognize your face, your eyes, that move you right through the line. It's the same thing with CITES. So you might be in for a long and drawn-out process, or you might be in for a 4-day quick turnaround when you file your permit request. It just depends which countries you're dealing with and what you're asking for.
The joys of technology. So we'll keep moving forward. Another question in the chat. and not necessarily related to biological samples, because I think everyone here realizes biological samples are different than live animals. But under CITES, what procedure is involved in moving a live elephant from, say, one country to another?
So the same procedure, let's just say for elephants, for most populations of elephants in the world, not all, because there are certain populations in Africa that are treated differently. For most elephants, they would be CITES Appendix 1. So you would have to have all three of those legal requirements, findings that I mentioned at the beginning. So non-detriment, non-det, we call it. So not detrimental to the survival of the species in the wild. Legal acquisition finding that that particular elephant was legally acquired wherever it is right now before it even goes to the next place. And third, because it's Appendix 1, that the trade, that the actual movement of that animal from one place to the other, the purpose of that is not primarily commercial. Then, because it's a live animal, there's a fourth thing that applies, and that is that that animal would be transported and cared for in a way that would meet its welfare needs. So there are transport guidelines. Those transport guidelines apply whenever you're moving live animals. And the transport guidelines apply whether it's by road, by rail, by truck, by plane, but they tend to rely on the very detailed requirements that exist for air transport under IATA, the International Air Transport Association, that develops what they call live animal regs, LAR. And those LARs are everything about, the size of the container, the type of the container, the material, whether you feed, you don't feed, access to water, all those different things are covered in the IATA LAR. And the CITES transport guidelines largely adopt and bring that in as a requirement for all forms of transport, with some adaptations, of course, where it's not a plane and where the thing is not relevant. So that would be the fourth big requirement if you were moving a live animal.
Excellent. Could you go into commercial versus non-commercial a little bit? There's been some confusion, and I think people don't understand the permit distinction there.
So there's a resolution that's been around since very early in the years of CITES, I think from the fifth conference of the parties, and it gets updated occasionally over the years. And it actually defines what is not primarily commercial, which is the test, not primarily for commercial purposes. So that's one piece of information. There's actually a definition. If you read that definition, you would realize that it is written quite broadly in the sense that if all of the non-commercial aspects don't predominate, it would be considered as commercial. So it's definitely, the definition is definitely skewed in that direction, with the pretty much the inference that trade is commercial, kind of unless you prove otherwise, sort of a setup. There's also the question of commercial and non-commercial when. And the answer to that is in another resolution that deals with permits and certificates. So permits and certificates have two different types of codes on them. One is a source code. Where did the specimen come from? Did it come from the wild? Then it's a W. Was it captive, born and bred under the CITES definition? It's a C. Is it something between those two? It's an F. Was it commercially created? That's a D. So source code and then purpose code. Purpose code, the letter that is put on the permit documents, records the purpose of the transaction. And the purpose of the transaction might be commercial. If it is, it's going to get a T code. Or it might be for some other purpose, for example, science, S, education, E, breeding, B, zoo, Z. So it goes like that. And if you read that resolution, it's very clear that what we are looking at for CITES purposes, because this is about international trade, is what is the purpose of the transaction we're talking about. Why do you want to move that elephant? Why are you moving that elephant from country A to country B? What is the purpose? It is not necessarily about downstream from there. However, countries can regulate in their own laws what you can do after you import. So you will find in the US government regulations, for example, there is a section that actually says what can be done with my CITES imported specimen. And then it tells you very clearly in terms of commerciality what can be done downstream. But that's not what CITES does. CITES is the import export and the focus on what is the purpose of the movement of the specimen. And is it for primarily commercial purposes or not?
Excellent. Great answer. And I think that basically brings us to the hour, and we've answered all the questions. So I'm just going to read this comment because I think this encapsulates what we all think. This was an excellent presentation, thorough presentation about subject matter that I knew almost nothing about. And I think, you know, a lot of the people in the chat are so happy that you were here to share this expertise with everyone. I know I learned a lot, and I'm not a newbie to this, but there's always more to learn, and you are our expert. So thank you so much.
You are welcome. And I'm going to end with one last little thing, which is that one of the decisions that was made in November of last year at the COP was to ask the Secretariat of CITES, which is based in Geneva, Switzerland, on their website to create links per country to their simplified procedures that more people can know about them, find them, and access them. So that has not yet been done, but it will be done in the next months. And I would encourage each of you to look at your own country's website. And if you don't see simplified procedures there, you should ask your government officials because that is something they could avail themselves of so that they can be more efficient with their resources as well. Thank you so much for your attention and interest in this topic.
Thank you. And that is a great way to end it because the simplified procedures will help conservation across the board. So hopefully we can make that happen. Julie, why don't you take it
Yes,
over?
thank you so much for everybody just sticking with us through this hour. And I'd like to invite everybody to turn your cameras on and let's give Laura a round of applause. Thank you so much, Laura, for such a wonderful presentation. I know I learned a lot as well, so we just really appreciate your time.